Earlier this year, the Supreme Court dealt the Voting Rights Act its most devastating blow in the 48 years since its enactment, when, by a 5-4 vote, it suspended the enforcement of crucial Section 5 of the Act. It gutted the very core of the law, and it meant that 9 states, mostly in the South, would be free to change their election laws without first getting pre-clearance approval from the federal government. We've been talking for months about the potential and likely ramifications of this decision, and this week we saw it play out in dramatic fashion on Election Day in one city in Texas.
Pasadena, Texas, a suburb of Houston, sometimes called Stinkadena for the smell of its chemical plants and oil refineries. Home to 150,000 people in the setting of the iconic film Urban Cowboy.
Real cowboy?
Orange blossom special.
Well, it depends on what you think a real cowboy is.
But like a lot of Texas towns, Pasadena has changed radically since the days when John Travolta walked the streets in a 10-gallon hat.
Pasadena no longer a small town, but a not-so-small city.
The change has come in the last 10 years thanks to explosive growth in the Hispanic population, which has risen in a decade from 48% to 62%, making white people a minority in the new Pasadena. Luckily for them, they are still a majority of the voting population. While the Hispanic population accounts for a majority of Pasadena residents, Hispanics make up only 32% of the city's voters. But the people who are running Pasadena see the writing on the wall. They know they're only a few voter registration drives and maybe a comprehensive immigration reform bill away from being relegated to minority status. So this summer, Pasadena Mayor Johnny Isbell came up with a plan. Right now, the city is run by the mayor and 8 council members. Each member is elected from one of 8 districts, each representing a section of the city. And for the first time in the city's history, there are now 2 Hispanics on the council. One is Cody Ray Wheeler.
We kind of came in there and we were looking to bring change, reform, to really engage in the community. And we've called the mayor out on a lot of things that we thought weren't very honest.
In August, Isbell started pushing a plan to shrink the number of districts from 8 to 6 and replace those 2 with at-large seats to be voted on by everyone in Pasadena. And by everyone, we mean the town's white voting majority.
He decided to make a full power grab, and he didn't care who would have to step over to get it.
To the community, the goal of the plan was pretty clear.
I think what he's trying to do is trying to stop us from being able to get the things that we need and be able to be the majority. He doesn't like it.
Dilute the power of the Hispanic vote and hand 2 council seats to the majority white voting population, ensuring the citywide majority white voting population could band together and retain their power.
What this effectively does is gives the south part of town, or the Anglo part of town, the majority of council.
It turns out this is precisely the sort of thing Section 5 of the Voting Rights Act was designed to block. In fact, Supreme Court Justice Ruth Bader Ginsburg cited this precise type of discrimination from a pre-Section 5 world when the Voting Rights Act came before the court earlier this year.
These second-generation barriers included racial gerrymandering, switching from district voting to at-large voting.
Did you hear that? At-large voting. It's the oldest trick in the book. And it's so immediately recognizable that when a neighboring Texas town of Beaumont cooked up a very similar at-large plan, it was blocked by the Justice Department in December 2012. But then the Supreme Court killed Section 5 of the Voting Rights Act in their 5-4 decision in Shelby v. Holder. And the mayor of Pasadena, Johnny Isbell, made his move.
He blatantly said at the first meeting we had, now that the pre-clearance from the Voting Rights Act is gone, we're going to redistrict the city.
In the mayor's own words,
the Justice Department can no longer tell us what to do.
And so this summer, Isbell, arguing that certain council members don't care about citywide issues, moved to put his own at-large plan on the ballot.
The mayor's quite aware of what this does. But like I said before, he just seems to not care.
And on Tuesday, the folks of Pasadena went to vote on Proposition 1, and the white voting majority won by a margin of 87 votes. Now that Section 5 is dead, there are thousands of potential Pasadenas all across the South.
We should note that Patricia Gonzalez, who we spoke to in that report, is a resident of Pasadena, also a community activist with the Texas Organizing Project. Joining me now is Julie Fernandez, former Deputy Assistant Attorney General in the Civil Rights Division of the Department of Justice, now a Senior Policy Analyst at the Open Society Foundations. All right, you used to work at a desk getting applications from places that wanted to do changes like this. How common or how anomalous is the story of Pasadena?
Well, I think changes to the method of election are actually the second most common type of voting change that drew objections during the days of Section 5. So the method of election changes were ones that often got a lot of scrutiny because you always have to ask the question why and assess the impact in the way your piece described.
I think what's interesting about this story is, if I'm not mistaken, the Shelby County case that actually came before the court that initiated the court striking it down was a not dissimilar case. It was actually a change to the gerrymandering of a district of a relatively small town. And what I think is interesting is we talk about voter ID and stuff that's happening at the state level. There is a lot of stuff that happens at the municipal level where these fights can get really nasty, and when the stakes are high, property taxes, school equity, things like that we don't necessarily see from the national level.
Well, and that's part of what we've lost here, Chris, when we lost Section 5, is we lost the ability to know about this stuff.
Right.
Everybody's going to know about statewide redistrictings. Everybody's going to know about statewide law changes. But places like Pasadena, Texas, or little towns, as you noted, Calera, Alabama, in Shelby County, all over the country, they're going to be doing things to manipulate the system, things to sort of define who the electorate is for their advantage that has a significant minority impact, and we're just not going to know about it because we don't have Section 5.
Just so people can see the map, these are the entire states that were formerly subject to pre-clearance, which no longer are. They range from Alabama, Alaska, Arizona, Georgia, Louisiana, Mississippi, South Carolina, Texas, and Virginia. Talk to me about the case of Beaumont, because that was a case in which you had basically a very similar set of facts and precisely the sort of thing the Justice Department said, no way.
Right. Just in December of 2012 is the perfect analogy. Just in December of 2012, the Beaumont ISD made a change. I think it was from 7 single-member districts to 5 single-member and 2 at-large. And DOJ,
Sounds familiar.
Yeah, it's very similar story in the same region of the state. And DOJ determined that that was going to have a retrogressive impact. And in this case, I think from your piece, it's also clear that there's a concern about there being a discriminatory purpose as well, which is a constitutional violation. And I think, in fact, we've seen in Texas a similar thing in Galveston, Texas, twice. I think once fairly recently, one in the late 90s. This is not an unusual technique in a situation where the minority population is growing.
Yep.
You have districts, and there's an attempt to say, how do we stop that growth from impacting outcomes in the election? It's classic.
So what is the recourse now that Section 5 isn't there? Pre-clearance is gone. The vote happened on Tuesday. The people that want to change to the mayor got his way. They've changed I think the city's constitution, essentially, the charter. So what can people do?
Well, I think the recourse is, and I think there are people looking at whether or not there's a way to challenge this under Section 2 of the Voting Rights Act, the part of the act that still is there, that you can use to affirmatively bring a lawsuit to say that this action was either purposely discriminatory or had a discriminatory effect. But those lawsuits take forever, Chris. They take a long time. They're expensive. If the plaintiffs have such a case and if they prevail, we're looking at 2 years or more before we're going to have a resolution. And that's 2 years with this a council elected under this system, which is an arguably discriminatory system.
That's 2 years
setting
where
the policy for that town.
2 years in which you have these 2 at-large districts, in which you may lose all Hispanic representation in this town that is actually majority Hispanic, and Lord knows what can be passed in the interim, which is the whole reason, the entire reason that Section 5 and Section 4 of the Voting Rights Act, the pre-clearance, was there. Julie Fernandez from the Open Society Foundation. Thank you so much.